Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Laws regarding retirement accounts and domestic relations vary significantly by state and are subject to change. The historical case studies and legal trends discussed are intended to provide context and are not a substitute for the counsel of a qualified attorney or financial professional in your specific jurisdiction. Viewers are strongly encouraged to conduct their own due diligence and consult with experts before making any decisions related to marital assets or retirement planning. Imagine working for 35 years, weathering the storms of the dot-com bubble, the 2008 housing collapse, and the unprecedented volatility of a global pandemic, all while diligently funneling a portion of every paycheck into your 401k. You watch that balance climb into the high 6 or even 7 figures, believing it is your fortress of solitude for your golden years. Then, a single signature on a divorce decree in a local county court changes everything. Suddenly, you realize that while your name is on the account, federal law and decades of American legal history have carved out a path for that fortress to be split right down the middle. This is not just a personal tragedy for many. It is a complex intersection of federal statutes, state property laws, and a historical evolution that most Americans do not understand until it is far too late. We are entering a masterclass on the 401k in the context of American legal history, a deep dive into how a sleeper provision in a 1978 tax law became the most litigated asset in the modern U.S. divorce court. The problem we are solving today is the information gap. Most people approach divorce thinking about the house or the car, but in the modern American economy, the 401k is often the largest liquid or semi-liquid asset a couple owns. By the end of this deep dive, you will understand the historical mechanisms that allow state courts to bypass federal protections, the specific legislative turning points that created the modern landscape, and the technical traps that have historically cost retirees hundreds of thousands of dollars in taxes and lost compounding growth. We are looking at the legal DNA of your retirement. To understand where we are, we have to look at the landscape before the 401k even existed. In the mid-20th century, the American retirement dream was built on the defined benefit plan, the pension. If you worked for a major manufacturer or a government entity, you didn't manage an account. The company managed a pool of money and promised you a check until you died. However, these pensions were notoriously difficult to divide in a divorce. If a spouse stayed home to raise children while the other earned a pension, the law often viewed that pension as the individual property of the worker. This created a massive social crisis where divorced spouses, primarily women, were left in poverty after decades of marriage because they had no legal claim to the future income of their partner's pension. The first major shift in this historical narrative occurred in 1974, with the passage of the Employee Retirement Income Security Act, commonly known as ERISA. This was a massive federal undertaking designed to protect employee benefits from mismanagement and corporate bankruptcy. One of the core tenets of ERISA was the anti-alienation provision. This rule stated that a worker's retirement benefits could not be assigned, turned over, or alienated to anyone else. It was meant to protect workers from creditors. If you owed a debt, your creditor couldn't touch your retirement. However, this created a legal shield that many workers used during divorce. They argued that because federal law ERISA prohibited the transfer of benefits, a state divorce court had no power to award a portion of a retirement plan to an ex-spouse. This created a decade of legal warfare between state family courts and federal law. State courts, which handle domestic relations, were trying to achieve equitable distribution of marital property, while federal law was saying hands off. This tension came to a head in the early 1980s. The legal history of this era shows a flurry of inconsistent rulings. Some judges would try to offset the retirement account by giving the other spouse more of the equity in the family home, while other judges felt their hands were tied, leading to outcomes that were perceived as fundamentally unfair based on the contributions of both partners to the marriage. The turning point that defined the modern era was the Retirement Equity Act of 1984, or REA. This is arguably the most important piece of legislation in the history of American divorce law that most people have never heard of. The REA was passed specifically to address the shield created by ERISA. It introduced a legal masterpiece known as the Qualified Domestic Relations Order, or the QDRO. For the first time in American history, the law created a specific key that could unlock the federal protections of a retirement account for the purposes of child support, alimony, or the division of marital property. The QDRO is a fascinating legal artifact because it represents a bridge between two different legal systems. On one side, you have the state court, which decides how much the spouse is entitled to. On the other side, you have the federal ERISA law and the plan administrator, the person at the company or the financial institution who manages the 401k. A standard divorce decree is not enough to move 401k money. The history of the 1980s and 90s is littered with cases where a spouse was awarded half a 401k in a divorce decree, but because they never filed a proper QDRO that met the strict federal requirements, the money was never moved. When the account holder retired or died, the ex-spouse found themselves with a worthless piece of paper and $0 in their account. As we look at the evolution of the 401k itself, we see why this became so high stakes. In 1978, Section 401k was added to the Internal Revenue Code almost as an afterthought. It was originally intended to allow high-level executives a way to defer some of their bonuses. It wasn't until a consultant named Ted Benner realized in 1980 that this provision could be applied to ordinary employees with a company match that the 401k revolution began. By the 1990s, companies were rapidly freezing their old-school pension plans and moving everyone toward 401ks. This shifted the risk from the employer to the employee, but it also changed the nature of the asset in a divorce. Unlike a pension, which was a promise of future money, a 401k was a bucket of current money. It had a balance. It had a daily value. This made it a much more visible and enticing target in legal proceedings. The historical trends show that as 401k balances grew, so did the complexity of the litigation surrounding them. One of the most significant deep dive points in this history is the concept of premarital versus marital portions. If an individual starts a 401k in 1995, gets married in 2005, and gets divorced in 2025, the legal battle isn't just about splitting the account in half. It is about tracing. This requires forensic accounting to determine what the account was worth on the day of the wedding and then, crucially, how much of the growth on that original premarital amount is also considered separate property. In many jurisdictions, the active appreciation, growth due to new contributions and management during the marriage, is treated differently than passive appreciation, market growth on money that was already there. This has led to historical case studies where millions of dollars hinged on the performance of the S&P 500 during specific quarters of a marriage. The legal burden of proof shifted to the person wanting to protect their assets, requiring them to produce statements from decades ago. Statements that many financial institutions, by historical standard, only kept for 7 to 10 years. This documentation gap has historically led to potential outcomes where individuals lost separate property simply because they couldn't prove its value from 20 years prior. Another layer of this masterclass is the tax implication history. Historically, taking money out of a 401k before age 59 and a half triggers a 10% early withdrawal penalty plus standard income tax. However, the legal history of the QDRO created a loophole, or more accurately, a specific provision. If money is moved from a 401k to an alternate payee, the ex-spouse, via a QDRO, the 10% penalty is waived if that spouse chooses to take the cash rather than rolling it over into their own IRA. This has been used strategically throughout the last 40 years as a way to fund the immediate costs of a divorce, such as buying a new home or paying legal fees, without the extra 10% sting. But the historical data suggests that many spouses who took the cash failed to account for the massive income tax hit, leading to a tax trap, where they received $100,000 from a QDRO, but ended up with a $30,000 tax bill they weren't prepared for the following April. We are seeing a trend in American legal history where the valuation date has become the primary point of contention. Is the 401k valued on the day of separation, the day the divorce is filed, or the day the judge signs the final decree? In a volatile market, the difference between these dates can be hundreds of thousands of dollars. Historically, courts have struggled to create a uniform rule, leading to a patchwork of potential outcomes, depending on which state or even which county you reside in. This deep dive into the 401k's role in American legal history reveals that it is not just a bank account. It is a battleground where federal law, state equity, and tax policy collide, requiring a level of precision that most people are never taught. To truly grasp the gravity of this battleground, we have to look at the geographical divide that defines American legal history: the clash between community property states and equitable distribution states. Imagine a man named David living in Austin, Texas, in 2026. David has been married to his wife Sarah for 15 years. Over those 15 years, David has been a high performer at a tech firm, accumulating a 401k balance of $850,000. In David's mind, that money belongs to him. His name is on the statement. His social security number is the primary identifier. His labor generated the contributions. However, because Texas is a community property state, the legal history of the Southwest dictates a very different reality. In the eyes of Texas law, every dollar David contributed to that 401k from the day he said "I do" until the day he files for divorce is considered community property. It does not matter whose name is on the account. It does not matter who did the work. The historical trend in these jurisdictions, which include California, Arizona, and Washington, is a strict 50-50 split of the marital portion. David is not just losing money, he is losing half of his financial identity. But the complexity deepens when we look at David's colleague, Mark, who lives in New York, an equitable distribution state. If Mark goes through a divorce in 2026 with the exact same $850,000 balance, the outcome is not a mathematical certainty. Equitable does not mean equal. The court in an equitable distribution state looks at a variety of factors: the length of the marriage, the age and health of both spouses, and even the future earning potential of each person. Mark might lose 40% or he might lose 60%. This creates a landscape of massive uncertainty where the legal history of your specific zip code determines the trajectory of your retirement. This brings us to the most powerful and least understood figure in the 401k divorce saga: the plan administrator. Most people believe that the judge in their divorce case has the final say. If the judge signs a paper saying Sarah gets half of David's 401k, David assumes the matter is settled. This is a dangerous historical misconception. Under the federal ERISA guidelines we discussed earlier, the plan administrator, the person or entity managing the 401k for the corporation, acts as a federal gatekeeper. They have a fiduciary duty to the plan, not to the state court. If the wording of your divorce decree or your qualified domestic relations order, the QDRO, deviates even slightly from the specific rules of that specific 401k plan, the plan administrator can, and often will, reject the order. Imagine David and Sarah spending $20,000 in legal fees to get a judge to sign their agreement, only for a plan administrator in a different state to send a cold, one-page letter stating that the order is non-qualified. Suddenly they are back to square one. This is why the historical trend has shifted toward lawyers using model language provided by the plans themselves. Yet even this is fraught with risk because model language is designed to protect the employer, not the individual spouses. Let's look at a case study involving a concept called vesting. Imagine a young professional named Jessica in 2026. She has been with her company for 4 years. Her 401k statement shows a total balance of $100,000, which includes a generous company match. However, her company uses a 5-year cliff vesting schedule. This means if she leaves before 5 years, she loses all of the company's contributions. If Jessica divorces in year 4, her spouse might claim half of that $100,000. But $40,000 of that balance isn't actually hers yet. It hasn't vested. The legal history of American divorce courts is filled with debates over unvested assets. Does the ex-spouse get a percentage of money that might vanish if Jessica is laid off next month? Or does the court wait until the money vests to trigger the payout? Historical trends show that courts increasingly view unvested 401k matches as a contingent property interest. They essentially place a lien on the account, waiting for the clock to hit that 5-year mark. This creates a legal tether between ex-spouses that can last for years after the divorce is finalized, leading to potential outcomes where people are forced to stay in contact with their ex-husbands or ex-wives just to track the status of a vesting schedule. Then we have the loan trap, a phenomenon that has exploded in frequency over the last decade. In the economic climate of 2025 and early 2026, many Americans took out loans against their 401ks to consolidate high-interest debt or to cover emergency expenses. When a divorce occurs, these loans become a radioactive element in the negotiations. A 401k loan is essentially you borrowing money from your future self. There is no creditor other than your own account. Consider the case of a couple, Robert and Elena. Robert took a $50,000 loan from his 401k to remodel their kitchen. When they divorced, the 401k balance is $200,000, but it has that $50,000 lien against it. Does Elena get half of the $200,000? Or half of the $150,000 of remaining cash? If the court orders the account to be split, the plan administrator usually cannot split the loan. If the loan isn't paid back immediately, it can be treated as a deemed distribution. This means the IRS steps in, treats that $50,000 as taxable income for the current year. And if Robert is under 59.5, they tack on a 10% penalty. Historical data suggests that thousands of divorcees every year are blindsided by these phantom taxes because they treated a 401k loan as a simple debt rather than a complex tax event. As we move deeper into the masterclass, we have to address the passive growth controversy. This is the holy grail for anyone trying to protect their retirement assets during a split. Imagine Michael, who entered his marriage with $200,000 in his 401k. 10 years later, the account is worth $500,000. Michael argues that the original $200,000 is his separate property. But what about the $300,000 in growth? In many states, the court will look at whether that growth was active or passive. If Michael was a day trader, constantly moving money between aggressive funds and taking an active role in the account's management, a judge might rule that his labor during the marriage caused the growth, making that $300,000 marital property. However, if Michael just left the money in a target date fund and never touched it, he has a historical legal basis to claim that the growth was passive, simply the market doing its work, and therefore should remain his separate property. The step-by-step detail required to prove this involves tracing exhibits, where experts recreate the account's history month by month for a decade. It is a grueling, expensive process that illustrates why 401k litigation is often the most resource-intensive part of a modern American divorce. But even if you win the battle of tracing, and even if you navigate the vesting cliffs and the loan traps, there is a silent predator waiting at the end of the process. Most people focus on the value of the 401k, but they forget the cost of the 401k. A 401k is a pre-tax asset. A house is a post-tax asset. If you are sitting in a courtroom and you trade $100,000 of 401k value for $100,000 of home equity, you have just made a catastrophic historical error in valuation. You have traded 100 cents on the dollar for roughly 70 cents on the dollar. Why is this the case? Because every time you pull a dollar out of that 401k in the future, the government is going to take their cut. The house equity for most people is largely tax-exempt up to certain limits. This tax-affecting of assets is where the most savvy legal minds in American history have separated themselves from the amateurs. If you don't adjust the value of the 401k for its future tax liability during the divorce settlement, you are essentially paying your spouse's future taxes. We have now covered the map, the gatekeepers, the vesting schedules, and the loans. But we haven't touched on the most dangerous scenario of all. What happens when the owner of the 401k dies before the QDRO is finished? There is a window of time between the divorce being final and the 401k being split where your retirement is in a legal no man's land. If the paperwork isn't perfect, your ex-spouse could either end up with everything or absolutely nothing, regardless of what the judge intended. In the next part, we are going to look at the death of a QDRO and the shocking case studies of the surviving spouse trap that has left thousands of American families in total ruin. The space between the moment a judge bangs the gavel on a divorce decree and the moment a 401k plan administrator officially qualifies a QDRO is known in legal circles as the gap period, or more morbidly, the danger zone. In the high-stakes world of American legal history, this specific window of time has produced some of the most heart-wrenching and financially devastating case studies in the record books. To understand why this happens, we have to look at the hierarchy of laws in the United States. While your divorce is governed by the laws of your state, whether that is Florida, Ohio, or California, your 401k is governed by a massive federal law called ERISA. When state-level family law and federal-level retirement law collide, federal law almost always wins. This is the doctrine of federal preemption, and it is the primary reason why a signed divorce decree is often not enough to protect your assets if tragedy strikes. Imagine a man named Thomas in the year 2026. Thomas has worked for a major aerospace firm for 30 years and has accumulated $1.2 million in his 401k. He and his wife, Julia, finalized their divorce in February 2026. The divorce decree, signed by a state judge, clearly states that Julia is entitled to exactly 50% of the 401k balance. Thomas, feeling a sense of relief that the legal battle is over, begins the process of moving on. However, the QDRO, the specific federal key needed to unlock those funds, is still being drafted by a specialist. In March 2026, before that QDRO is ever sent to the plan administrator, Thomas suffers a fatal heart attack. In a world governed by common sense, Julia would simply show the death certificate and the divorce decree to the aerospace firm and collect her $600,000. But American legal history tells a different story. Because the QDRO was never qualified, the plan administrator is legally obligated to look at exactly one thing: the beneficiary designation form on file. If Thomas never updated that form, or if the form still lists Julia as the 100% beneficiary, a massive legal conflict erupts. However, the more common tragedy is when Thomas has already changed the beneficiary to his children or a new partner. Under the precedent set by the landmark 2009 Supreme Court case Kennedy v. Plan Administrator for DuPont Savings and Investment Plan, the plan must pay the person named on the official plan documents, regardless of what a state divorce decree says. In the Kennedy case, the ex-wife had even signed a waiver specifically giving up her right to the retirement funds, but because the husband never updated the beneficiary form with the company, the Supreme Court ruled that the company was right to pay the money to the ex-spouse anyway. This created a historical trend where the plan document is considered sacred, often overriding the clear intent of the deceased. This brings us to the technical necessity of the pre-retirement survivor annuity, or the PRSA. One of the most common mistakes in American legal history is the failure to include survivor benefits within the QDRO itself. If you are the spouse receiving the money, you must ensure the QDRO explicitly states that you are to be treated as the surviving spouse for the purposes of the plan should the participant die before the transfer is complete. Without this specific language, the moment Thomas dies in our 2026 scenario, his 401k might revert to a default status defined by the employer's plan. Some plans state that if a participant dies without a qualified order in place, the entire balance goes to the current spouse or, if there is no spouse, to the estate. If Julia isn't named as the surviving spouse in a qualified QDRO, she could potentially lose every penny of that $600,000, even though a judge had already awarded it to her. To combat this, legal scholars and top-tier family attorneys have developed the separate interest QDRO. This is a step-by-step master maneuver that effectively splits the account into two completely independent piles of money as soon as the order is qualified. In a separate interest QDRO, Julia would get her own account within the plan, or the funds would be rolled over into her own IRA. Once this happens, the fate of Thomas no longer affects her. If Thomas dies the next day, Julia's $600,000 is safe because it is no longer legally tied to his life. Historically, this has been the gold standard for protecting non-employee spouses. However, there is a catch. Not all plans allow for a separate interest QDRO. Some plans, particularly older ones or those that have been grandfathered in from previous eras, only allow for a shared interest QDRO. In a shared interest scenario, Julia only gets paid when Thomas gets paid. If Thomas dies before he retires, the payments might never even start. The historical data on these dead QDROs led to the rise of the nunc pro tunc order. This is a Latin term meaning now for then. In cases where a spouse died during that gap period, lawyers would rush back to the state court and ask the judge to sign a QDRO and backdate it to a time before the death occurred. For years, this was a common fix-it strategy in American courts. But the legal history took a sharp turn as federal courts began to push back. Many federal circuits now hold that a nunc pro tunc order cannot create a right that didn't exist at the time of death. This has turned the gap period into a literal race against time. In 2026, the speed of digital filing has increased, but the complexity of plan-specific requirements has also increased, meaning the risk is just as high as it was decades ago. Furthermore, we must address the second spouse complication, a scenario that has become increasingly common as the average age of divorcees in the U.S. rises. Imagine if Thomas, instead of dying, had remarried just weeks after his divorce from Julia was finalized. Under ERISA law, the moment Thomas says, "I do" to his second wife, she gains certain federal rights to his retirement plan. If a QDRO for Julia hasn't been qualified yet, the new wife's federal rights might conflict with Julia's state law rights. This creates a three-way legal battle between the ex-wife, the new wife, and the plan administrator. Historical case studies show that in these instances, the plan administrator often freezes the account entirely and files what is known as an interpleader action. This essentially means the company hands the money over to a federal court and says, "We don't know who to pay, you figure it out." The result is years of litigation and hundreds of thousands of dollars in legal fees, often consuming a significant portion of the 401k itself. The level of detail required to avoid these outcomes is staggering. You have to account for cost of living adjustments, early retirement subsidy rights, and even the plan investment options during the period of the split. If the 401k is 100% invested in a high-risk tech fund, and the market crashes while you are waiting for the QDRO to be qualified, who bears that loss? If the QDRO specifies a dollar amount, say exactly $600,000, the participant bears the market risk. If the QDRO specifies a percentage, 50%, then both parties ride the market up or down. Historical trends show that many people who thought they were getting a specific pot of money ended up with much less because they didn't understand the valuation date mechanics of the QDRO. This brings us to a critical realization. The 401k is a living, breathing financial entity that is constantly changing in value, and the legal documents used to split it must be equally dynamic. We have seen how death and remarriage can derail a retirement split, but what happens when the 401k isn't just sitting there? What if the participant is still actively contributing to it? Or worse, what if they are actively withdrawing from it while the divorce is pending? The next layer of this masterclass involves the internal audit and the automatic temporary restraining order, ATRO. The invisible shield that is supposed to prevent your retirement from vanishing before you even get to court. But as we will see, shields can be broken, and the potential outcomes for those who don't act fast are often irreversible. In the next part, we are going to dive into the liquidated asset nightmare and how spouses use shadow loans to drain 401ks before a QDRO can even be drafted. The liquidated asset nightmare begins not with a legal filing, but with a quiet login to a benefits portal. In the American legal landscape of 2026, the 401k has transitioned from a long-term retirement vehicle into what many litigators call a shadow checking account. To understand the gravity of this, imagine a character named Brian. Brian lives in a suburb of Chicago and has spent 20 years climbing the corporate ladder at a logistics firm. His 401k balance sits at a comfortable $600,000. In early 2026, sensing that his marriage to Linda is reaching a breaking point, Brian decides to take proactive measures. He is aware that once a divorce is officially filed, he will likely be served with an automatic temporary restraining order, or ATRO. In the history of American domestic relations law, the ATRO is intended to be the ultimate freeze. In states like California, New York, and Illinois, these orders are automatically triggered the moment a summons is served. They legally prohibit either spouse from transferring, encumbering, or concealing any property, whether it is held individually or jointly, without the written consent of the other party or a court order. The goal is to preserve the status quo. However, the historical trend shows a massive gap between legal theory and technical reality. The 401k plan administrator, often located in a different state and operating under federal ERISA guidelines, usually has no idea an ATRO exists in a local county court. Unless a specific joinder or a separate notice is filed with the plan itself, the gates remain wide open for the account holder. Brian, acting before the ATRO is served, or perhaps in bold defiance of it, decides to utilize the 401k loan provision. Under current IRS regulations, an individual can typically borrow up to 50% of their vested balance, capped at $50,000. Brian takes the full $50,000. In his mind, he is simply moving his own money. But in the eyes of the law, he is committing what is known as the dissipation of marital assets. Dissipation is a term in American legal history that refers to the use of marital property for the sole benefit of one spouse, for a purpose unrelated to the marriage, at a time when the marriage is undergoing an irreconcilable breakdown. The step-by-step detail of how this shadow loan impacts the divorce is complex. When the 401k is eventually valued for the QDRO, the balance will appear as $550,000 instead of $600,000. If Linda's attorney is not diligent, the $50,000 loan might be overlooked as a simple market fluctuation or a prior expense. However, the historical legal trend in 2026 is for courts to use the add-back method. If Linda can prove that Brian took that loan to deplete the marital estate, perhaps he used the cash to fund a separate apartment or invested it in a high-risk cryptocurrency account that vanished, the court will treat that $50,000 as if it were still sitting in the 401k. Imagine the potential outcomes here. If the court determines the total marital pot should have been $600,000, and Linda is entitled to 50%, her share is $300,000. Since Brian already took $50,000, his remaining share of the actual cash in the account drops to $250,000. Brian's attempt to hide the money backfires because he is now left with a smaller portion of the liquid asset and a $50,000 debt to his own retirement plan that he must still pay back with interest. This is a classic case study in how tactical maneuvers without legal foresight often lead to a net loss for the perpetrator. But what if the depletion is more aggressive? In American legal history studies, we find cases of the hardship withdrawal. Unlike a loan, a hardship withdrawal is not paid back. It is a permanent removal of funds. In 2026, the criteria for these withdrawals have historically expanded to include preventing eviction, paying for funeral expenses, or certain medical bills. If a spouse like Brian falsifies a hardship or exaggerates a financial crisis to the plan administrator, they can effectively drain huge portions of the 401k before a spouse can get a court date. The legal history of the mid-2020s shows an increase in these scorched earth tactics. The consequence for this is often a finding of marital waste. When a judge finds that a spouse has committed marital waste, the penalties can go beyond simple add-backs. In some jurisdictions, the court may award the innocent spouse a larger percentage of the remaining assets to compensate for the lost funds. This could mean Linda receives 60 or 70% of what is left of the 401k. Furthermore, in extreme cases of fraud or defiance of an ATRO, a judge may even order the offending spouse to pay the other party's legal and forensic accounting fees. The data suggests that the cost of hiring a forensic accountant to trace these 401k leaks can range from $5,000 to $20,000. A fee that can be shifted entirely to the spouse who tried to hide the money. We must also look at the strategic use of 401k contributions during the divorce process. Imagine if Brian, instead of taking a loan, simply stops his 15% contribution to his 401k the day he decides to divorce. He shifts that money into a private, undisclosed savings account. Historically, this has been a gray area in American law. Is he required to continue contributing to a marital asset at the same rate? Or is he allowed to manage his income as he sees fit once the separation begins? The historical trend is shifting toward a requirement of consistency. Courts are increasingly skeptical of sudden changes in financial behavior that occur immediately before or during a divorce filing. This deep dive wouldn't be complete without discussing the 401k as a tool for coercive control. This is a concept that has gained significant traction in legal history over the last decade. In this scenario, the spouse with the 401k uses the complexity of the QDRO process as a weapon. They might refuse to provide the necessary plan documents, intentionally fill out forms incorrectly to trigger a rejection from the plan administrator, or delay the process for years. Because the non-employee spouse is often in a position of financial vulnerability, the gatekeeper spouse uses the 401k as leverage to force a settlement in other areas, such as custody or the sale of the family home. The step-by-step defense against this is the appointment of a QDRO specialist. Rather than letting the opposing attorneys fight over the wording, the court can appoint an independent expert to draft the order. This removes the weaponization factor. But even with an expert, the time it takes to process these orders, often 3 to 9 months, remains a significant hurdle. During this time, the market continues to move. In a volatile 2026 economy, a 401k that was worth $600,000 in January could be worth $520,000 by the time the QDRO is ready in October. Who bears that market loss? If the order was written for a fixed dollar amount of $300,000, Brian is the one who suffers the $80,000 drop. If it was a percentage, they both share the pain. As we conclude this section on the liquidated asset nightmare, we realize that the 401k is not just a pile of money. It is a dynamic, shifting target that requires constant surveillance during a divorce. The shadow loan is just the tip of the iceberg. What happens when the money isn't just being moved, but is being recharacterized? What if a spouse tries to argue that a portion of the 401k isn't actually a 401k, but a disability benefit or a personal injury settlement that was rolled in? This leads us into the next phase of our masterclass, the characterization conflict. We are going to explore how spouses attempt to relabel their retirement accounts to make them invisible to the divorce court, and the forensic tools used to unmask these hidden assets. But first, we must address the single most expensive mistake a spouse can make during the QDRO process: the segregated account failure. We will see how failing to account for dividend reinvestment during the gap period can cost a spouse tens of thousands of dollars in phantom growth. In the next part, we dive into the missing millions of reinvested dividends. The missing millions of reinvested dividends represent one of the most significant, yet invisible leaks in the modern American divorce process. To understand why this happens, we must look at the mechanics of how a 401k actually functions within a brokerage environment in 2026. Most people view their 401k balance as a single static number on a screen, but that number is the result of thousands of microtransactions. When you own shares in a mutual fund or an exchange-traded fund within your 401k, those funds often pay out dividends or capital gains distributions. In a standard retirement account, these are set to automatically reinvest, meaning they immediately purchase more shares of that fund. In a high-growth or high-dividend yield portfolio, this reinvestment is the silent engine of compounding interest. Imagine a character named Jennifer. It is mid-2026, and Jennifer is finalizing a divorce from her husband Marcus, who has a 401k balance of $1.5 million. After months of mediation, they agree to a 50-50 split. The court sets the valuation date as January 1, 2026. On that day, Jennifer is technically entitled to $750,000. However, the legal system moves slowly. Between the valuation date in January and the actual implementation of the QDRO in November 2026, 10 months pass. During these 10 months, the market experiences a rally, and the funds within the 401k pay out substantial quarterly dividends. Because the 401k is still in Marcus's name and under his control, those dividends are automatically reinvested into his account. This is where the historical trend of poor QDRO drafting leads to a massive loss of value. If Jennifer's attorney drafts a QDRO that simply states Jennifer is awarded the sum of $750,000 from the plan as of January 1, 2026, the plan administrator will do exactly that. They will cut a check or move exactly $750,000 into Jennifer's new account in November. But what happened to the growth on that $750,000 during those 10 months? If the market grew by 8% and dividends added another 2%, that $750,000 should have actually become $825,000. By failing to include a specific technical phrase, Jennifer has effectively gifted Marcus $75,000 of her own retirement growth. In American legal history, this is known as the earnings and losses trap. The historical data from 2020 through 2025 shows that market volatility can make this gap period swing wildly. If the QDRO does not explicitly state that the award includes pro rata earnings and losses from the valuation date to the date of distribution, the non-employee spouse is essentially a spectator to their own wealth. Step by step, a professional QDRO specialist in 2026 will insist on language that accounts for these fluctuations. This involves instructing the plan administrator to calculate the investment performance of the specific funds Jennifer's portion was invested in, and apply that percentage to her award. Without this, the employee spouse receives all the market upside on the entire account, even the portion they no longer technically own. But the risk isn't just about missing out on growth, it is also about the segregated account failure. Imagine if, during that same 10-month gap, Marcus decides to get aggressive. Perhaps he hears a rumor about a specific sector and moves the entire $1.5 million into a high-risk, leveraged investment. If the market turns and the account value drops by 30%, the total balance falls to $1,050,000. If Jennifer's QDRO was for a fixed $750,000 without earnings and losses language, she might think she is safe. However, many 401k plans have a maximum percentage rule. If the account balance drops so low that the fixed dollar amount exceeds a certain percentage of the remaining total, the plan administrator may reject the QDRO entirely, forcing the parties back to court. The historical solution to this has been the move toward the segregated account. A sophisticated legal strategy in 2026 involves serving the plan administrator with a draft QDRO or a notice of adverse interest immediately upon filing for divorce. Some plans, upon receiving this notice, will allow for the segregation of the disputed funds into a separate, low-risk money market account within the plan. This effectively ring-fences the $750,000, protecting it from the other spouse's investment whims and ensuring that it is available when the final order is signed. The step-by-step detail of this process requires a deep understanding of the specific summary plan description for that employer, as every corporation has different rules for how they handle segregated interests during a pending domestic relations matter. We also see the emergence of the phantom growth conflict in cases involving company stock. Many 401ks, particularly for employees of major firms like Apple, Amazon, or Tesla, contain a significant portion of employer securities. These stocks don't just have dividends, they have stock splits and spin-offs. In the history of American corporate law, a spin-off can create a completely new asset. If a company spins off a subsidiary and the 401k holders receive shares in that new entity, a QDRO that only mentions the original 401k plan might not cover the new shares. This has led to historical case studies where ex-spouses spent years in appellate courts fighting over whether a new tech company's shares were part of the original marital award or a separate, post-divorce windfall for the employee. Data from recent legal audits suggest that nearly 30% of 401k divisions in the United States contain some form of valuation error related to the gap period. This is often because the lawyers involved are generalists who understand the broad strokes of family law, but do not understand the granular, day-to-day operations of ERISA-governed retirement vehicles. The potential outcomes of these errors are cumulative. If you lose $50,000 in growth in your late 30s due to a poorly drafted QDRO, that $50,000 is not just a one-time loss. When you factor in 25 years of lost compounding growth at a historical average of 7%, that single mistake has cost you nearly $270,000 in final retirement value. Furthermore, we must address the issue of loan repayments during the gap period. As we discussed in the previous section, if a spouse has an outstanding 401k loan, they are likely making repayments through payroll deductions. Each repayment increases the cash balance of the 401k. If the valuation date was set before these repayments were made, who gets the benefit of that new cash? Does it all go to the employee who worked for the paycheck, or is it considered a marital asset because the loan was a marital debt? The legal history of the 2020 shows a trend toward crediting the repaying spouse for those contributions, but the math required to separate those repayments from market growth and dividends is so complex that many couples simply give up and split the difference, often to the detriment of the person who actually put the money back in. This deep dive into the technicalities of dividends, segregation, and gap period growth reveals that the QDRO is not a static document, but a set of instructions for a complex financial machine. If the instructions are vague, the machine will default to the easiest path, which almost always favors the plan participant and the employer's administrative convenience over the equitable distribution of the marital estate. But as complex as the 401k division is, there is a hidden layer that is even more difficult to navigate: the characterization conflict. This is where spouses attempt to relabel their 401k assets to move them out of the reach of the court entirely. They might claim that a portion of the account is not actually retirement savings, but a disability settlement or a personal injury award that was rolled in, which in some states makes it separate property. In the next part, we are going to explore the world of the forensic audit and the specialized tools used to unmask these relabeled assets. We will also look at the rise of the digital nomad divorce, where spouses try to move their 401k assets into international jurisdictions to evade U.S. court orders. In the next part, we go deep into the forensic hunt for the hidden 401k. The forensic hunt for the hidden 401k begins with a simple truth. In the digital age, everyone leaves a trail, but most people do not know how to read the breadcrumbs. In the American legal landscape of 2026, the complexity of career paths, with workers jumping from gig to gig or switching corporate roles every few years, has created a massive graveyard of lost retirement accounts. But in a divorce, these accounts are not just lost. They are often strategically forgotten. To understand the forensic process, imagine a character named Samantha. Samantha is an executive in Seattle who has worked for 4 different tech companies over the last 15 years. Her husband, Alex, knows about her current 401k because it appears on her bi-weekly pay stubs. However, Samantha has 3 other accounts from previous employers that she has not mentioned. This is where the historical trend of the mandatory disclosure comes into play. In every state court from Florida to Oregon, spouses are required to sign a financial affidavit under penalty of perjury. But the history of American litigation shows that omission is the most common form of financial fraud. To unmask Samantha's hidden assets, Alex's legal team must move beyond her current statements and look at the Form 5500 and the Social Security Administration's earnings records. Every time a company sponsors a 401k plan, they must file a Form 5500 with the Department of Labor. By cross-referencing Samantha's employment history with these public filings, a forensic accountant can identify every plan she was eligible for. Furthermore, the Social Security Administration keeps a record of potential private retirement benefits. Historically, when you leave a job, the plan administrator notifies the SSA that you have a vested interest. A simple request for an SSA earnings record can reveal a roadmap of accounts Samantha thought were invisible. But even when an account is found, we run into the characterization conflict. This is a sophisticated legal maneuver where one spouse attempts to relabel a portion of the 401k to make it non-marital. Imagine if Samantha argues that $200,000 of her $1.5 million 401k balance actually came from a personal injury settlement she received back in 2019 after a car accident. In many U.S. jurisdictions, money awarded for pain and suffering is considered the separate property of the injured spouse, even if it was received during the marriage. However, if Samantha commingled that settlement by rolling it into her 401k, the legal history of transmutation suggests she may have lost that separate status. The step-by-step forensic audit required here is intense. Alex's team must perform a tracing analysis. They have to go back to 2019, find the exact date the settlement check was deposited, and track it as it moved into the retirement account. If the account also received marital contributions and dividends during that time, the money is like red ink in a pool of blue water. Unless Samantha can prove exactly which molecules of the money are hers through a strict first in, first out or pro rata accounting method, the court is likely to rule that the entire account is marital property. This characterization conflict is the reason why 401k divorces in 2026 often involve thousands of pages of bank records and expert testimony. As we move into the era of the digital nomad, the stakes for international evasion have increased. Imagine a spouse named Kevin, a software architect who decides in early 2026 that he wants to move to a jurisdiction like Singapore or the Cayman Islands. Kevin knows that a U.S. court can issue a QDRO to a U.S.-based company like Fidelity or Vanguard. But what if Kevin cashes out his 401k entirely, pays the massive tax penalties, and moves the remaining $700,000 to an offshore bank account before his wife can file for divorce? This creates a jurisdictional nightmare. While the U.S. court still has in personam jurisdiction over Kevin, meaning they can order him to bring the money back, they lose in rem jurisdiction over the money itself. Historically, the potential outcomes for the spouse left behind are grim. If the money is gone from the U.S. financial system, the QDRO becomes a useless piece of paper. The legal history of these international asset shifting cases shows that courts will often use offsetting awards. If the 401k is gone, the judge may give the wife 100% of the family home or other domestic assets to make her whole. But if the 401k was the only major asset, the wife is left chasing a ghost in an international court, illustrating why the freeze order we discussed earlier must be served on the plan administrator, not just the spouse, at the very first hint of a split. Then there is the shadow account phenomenon. In the high-stakes world of 2026 finance, some executives have non-qualified deferred compensation plans. These look and act like 401ks, but they are not governed by ERISA. Because they are not ERISA governed, a standard QDRO does not work on them. Historically, many spouses have walked away from a divorce thinking they split all the retirement accounts, only to find out years later that the big fish, the non-qualified executive plan, was never touched because it wasn't labeled as a 401k on the financial statements. Forensically, you find these by looking at the W-2 forms. If there is a code V or other specific markers in box 12 of the W-2, it indicates that money is flowing into a plan that doesn't follow the standard 401k rules. The depth of this forensic hunt reveals that a 401k is often just the visible tip of a much larger financial iceberg. To be successful in a 2026 divorce, a spouse must understand the flow of funds. This involves a step-by-step review of tax returns over the last 5 to 10 years. A forensic accountant will look at Schedule 1 of the Form 1040 to see adjustments to income. If a spouse is claiming a deduction for retirement contributions that don't match the 401k statements provided, it is a red flag that a hidden IRA or a secondary 401k exists. We also see the automatic rollover trap. Historically, if you leave a job with less than $5,000 or $7,000 under newer 2024 to 2026 regulations in your 401k, the company can force you out of the plan. If you don't tell them where to send the money, they often set up an automatic IRA in your name at a provider of their choice. Thousands of Americans have these zombies IRAs floating around, accumulating fees and small amounts of growth, completely forgotten until a divorce subpoena hits the right clearinghouse. This brings us to a critical realization for our masterclass. The hidden 401k is rarely a secret offshore account. It is usually a mundane, forgotten account from a job held a decade ago that has now grown into a six-figure asset. The failure to find these accounts isn't just a loss of current cash. It's a loss of the historical basis of the couple's wealth. But finding the money is only half the battle. Once you find it, you have to deal with the IRS. In the next part of our series, we are going to dive into the tax guillotine. We will look at the 20% mandatory withholding, the 10% early withdrawal penalty, and the Section 72T strategy that savvy divorcees use to access their 401k cash without paying the penalty. We will also explore the net unrealized appreciation (NUA) trick that can turn high-tax 401k distributions into low-tax capital gains, if you know the specific historical sequence of moves to make. In the next part, we tackle the tax wars of the QDRO. The tax wars of the QDRO represent the most technical and high-stakes phase of the 401k divorce saga. In the American legal history of taxation, the Internal Revenue Code is often seen as a rigid wall, but for those navigating a divorce in 2026, there are specific, historically established windows that allow for the movement of capital in ways that are otherwise impossible. To understand these maneuvers, we have to look at the intersection of Section 414P and Section 72T of the tax code. These are not just numbers. They are the gears that determine whether a spouse keeps their award or loses nearly half of it to the federal government before they even see a dime. Imagine a character named Elena living in Chicago in 2026. Elena has just been awarded $300,000 from her ex-husband's 401k through a meticulously drafted qualified domestic relations order. Elena is 42 years old. Under normal circumstances, if anyone under the age of 59 and a half tries to pull $300,000 out of a 401k, they are met with the tax guillotine, a mandatory 10% early withdrawal penalty on top of their standard income tax rate. This penalty was historically designed to discourage Americans from using their retirement accounts as emergency savings. However, the legal history of the QDRO created a singular powerful exception. Under Internal Revenue Code Section 72T, 2c, payments made to an alternate payee pursuant to a QDRO are exempt from the 10% early withdrawal penalty. This exception is one of the most significant strategic tools in American divorce law. For Elena, this means she can choose to take a portion of her $300,000 award as a cash distribution to help fund her transition into a new home or pay off high-interest debt without the 10% sting. If she takes $100,000 in cash, she potentially saves $10,000 in penalties alone. But this is where many people fall into a historical tax trap known as the 20% mandatory withholding. Following the Unemployment Compensation Amendments of 1992, federal law requires 401k plan administrators to withhold exactly 20% of any distribution paid directly to an individual for federal income tax. Step by step, the math for Elena looks like this. She requests $100,000 from the plan. The administrator, bound by federal law, sends $20,000 to the IRS and $80,000 to Elena. This is not the final tax bill. It is simply a down payment. If Elena is in a high tax bracket in 2026, she may owe even more when she files her returns. Historical trends show that many divorcees mistake this 20% withholding for the total tax obligation, leading to a massive unexpected bill the following April. This illustrates why the potential outcomes of a cash distribution must be modeled by a tax professional before the QDRO is even submitted to the judge. The most dangerous mistake in this entire process is the IRA rollover trap. In the legal history of retirement assets, an IRA and a 401k are treated very differently during a divorce. If Elena takes her $300,000 award and rolls it over into her own individual retirement account, IRA, first, she has just closed the window on the 10% penalty waiver. The Section 72T exception applies only to distributions taken directly from the 401k plan under the QDRO. Once the money touches an IRA, it is governed by IRA rules, which do not have the same divorce-related penalty waiver for early withdrawals. We have seen countless case studies where a spouse, following the advice of a well-meaning but underinformed financial advisor, rolls the money into an IRA and then tries to withdraw cash for a down payment on a house, only to realize they have just triggered a 10% penalty that could have been avoided. Now let's look at an even more sophisticated historical maneuver: net unrealized appreciation, or NUA. This is specifically relevant for employees of major American corporations who hold company stock within their 401k plans. Imagine a character named Marcus in 2026, who is an executive at a company like FedEx or General Electric. His 401k is packed with company stock that has appreciated significantly over 20 years. If Marcus's ex-wife Sarah is awarded half of this stock, she has a choice. She can roll it over into an IRA, where it will eventually be taxed as ordinary income upon withdrawal, potentially at a rate as high as 37%. However, the NUA strategy, rooted in decades of tax law evolution, allows Sarah to move that company stock into a taxable brokerage account rather than a retirement account. Step by step, the tax treatment changes fundamentally. She pays ordinary income tax only on the cost basis what the stock was worth when it was first put into the plan, but the appreciation, the growth, is taxed at the much lower long-term capital gains rate, which historically tops out around 20% for most. In a high-stakes divorce involving millions in company stock, the NUA strategy can result in potential outcomes where the spouse saves hundreds of thousands of dollars in future taxes. But the catch is historical precision. If the distribution is not a lump sum distribution of the entire account balance within a single tax year, the NUA tax treatment is lost forever. This brings us to the substantially equal periodic payments, SEP, also known as the Section 72T payment plan. For a spouse who needs a steady stream of income before age 59 and a half, but wants to avoid the 10% penalty on an IRA, the legal history of the 1980s provided a solution. By committing to a series of payments based on life expectancy for at least 5 years, or until they reach 59 and a half, whichever is longer, a divorcee can bypass the penalty. This is a high-wire act. If Marcus or Sarah misses a single payment or changes the amount by even $1, the IRS historically busts the plan, and all previous penalties that were waived are suddenly due immediately, with interest. The data on QDRO tax errors suggests that the complexity of these rules creates a natural barrier to entry for the average person. Between the 20% withholding, the 10% penalty waiver, the NUA capital gains shift, and the SEP requirements, the 401k becomes a Rubik's Cube of tax liability. We are seeing a historical trend in 2026 where specialized tax attorneys are being brought into divorce mediations earlier than ever before to ensure that the wording of the QDRO doesn't just split the asset, but does so in a way that minimizes the tax leakage. As we master the tax implications, we must also address the administrative reality of 2026. What happens when the company itself is in flux? In the next part of our deep dive, we are going to explore the corporate merger chaos. We will look at what happens to your QDRO when your spouse's company is bought out, the 401k plan is terminated, or the plan administrator changes in the middle of your divorce. This is the moving target scenario that has left thousands of American divorcees with frozen accounts and legal bills that never end. We will also dive into the blackout period nightmare, where you are legally barred from moving your money for weeks or months during a system upgrade. In the next part, we tackle the corporate instability that can sink your retirement split. Corporate instability is the invisible wrecking ball of the 401k divorce process, often swinging just as the parties believe they have reached the finish line. In the American legal landscape of 2026, the corporate world is defined by rapid-fire mergers, acquisitions, and strategic restructuring. For a couple in the middle of a retirement asset split, this volatility can turn a standard legal procedure into a multi-year administrative nightmare. To understand the mechanics of this chaos, imagine a character named James who has worked for a mid-sized cloud computing firm in Denver for 12 years. James is in the final stages of a divorce from his wife Chloe. Their settlement agreement, reached in early 2026, stipulates that Chloe will receive exactly $450,000 from James's 401k. The attorneys have drafted the Qualified Domestic Relations Order, or QDRO, specifically naming the CloudTech 401k savings plan as the source of the funds. However, while the document sits on a judge's desk awaiting a signature, CloudTech is suddenly acquired by a massive multinational conglomerate called Titan Global Industries. As part of the merger, the CloudTech 401k plan is officially terminated, and all assets are rolled into the Titan Global Retirement umbrella. This is the moment where the historical trend of administrative rejection begins. When Chloe's attorney finally sends the signed QDRO to the plan administrator, the response is a cold, bureaucratic denial. The reason? The CloudTech 401k savings plan no longer exists. In American legal history studies, this is known as the successor plan conflict. Federal ERISA law requires that a QDRO be technically perfect. If the plan named in the court order is not the plan currently holding the assets, the plan administrator has no legal authority to move the money. Step by step, James and Chloe are forced back to square one. They must now amend their divorce decree, draft a new QDRO naming the Titan Global Plan, and get a new signature from the judge. This process can take months and cost thousands in additional legal fees. This illustrates a critical historical lesson for 2026. Any well-drafted QDRO must include a successor and interest clause. This specific technical language ensures that the order remains valid even if the plan changes names, merges with another entity, or is taken over by a new provider. Without this clause, the ex-spouse is essentially chasing a moving target. But the merger itself is only part of the problem. We must also address the blackout period. A blackout period is a time frame, usually lasting between 30 and 60 days, during which all administrative actions on a retirement plan are frozen. This typically happens during a system upgrade, a change in plan providers, or a corporate merger. During a blackout, participants cannot change their investment allocations, take out loans, or, most importantly for our masterclass, process a QDRO. Imagine Chloe has already committed to a down payment on a new home, expecting her $450,000 distribution to arrive in June 2026. If the Titan Global merger triggers a blackout period that runs from May through July, Chloe's funds are legally locked in a vault she cannot reach. The historical data on blackout periods shows that they are one of the leading causes of post-divorce litigation. Because the plan administrator's primary fiduciary duty is to the plan as a whole, not to the individual needs of an ex-spouse, they are under no obligation to expedite a QDRO just because someone is waiting on house closing. This creates a potential outcome where the timing of a corporate merger can lead to the total collapse of a spouse's post-divorce financial plan. The only defense in this scenario is a deep dive into the Summary Plan Description or SPD, which by law must provide notice of upcoming blackouts. However, many ex-spouses are never given access to these documents, highlighting the information gap that defines 401k litigation. Now let us consider an even more dire scenario: plan termination due to corporate bankruptcy. Imagine a character named Kevin who works for a legacy retail chain that enters Chapter 11 bankruptcy in late 2026. Kevin's 401k is managed by a third-party custodian, so the funds are technically shielded from the company's creditors under ERISA's anti-alienation provisions. However, as part of the liquidation, the company decides to terminate the 401k plan entirely. In a plan termination, all participants are given a window to roll their money into a new IRA or take a cash distribution. If Kevin's wife, Rebecca, is in the middle of a QDRO process when the plan terminates, she is in a race against the clock. If the plan administrator distributes Kevin's entire balance to him before Rebecca's QDRO is qualified, the money leaves the protection of the federal ERISA shield. Once that money is in Kevin's personal bank account, it is no longer subject to a QDRO. Rebecca's legal team would have to sue Kevin personally in state court for a breach of the divorce decree, a process that is significantly more difficult, expensive, and uncertain than a direct transfer from a 401k. Historical case studies from the early 2000s bust show that thousands of spouses lost their retirement interest during plan terminations because their legal teams did not move fast enough to serve the plan administrator with a notice of adverse interest. The technical detail required to survive a plan termination involves the anti-cutback rule under Internal Revenue Code Section 411(d)(6). This rule generally prevents an employer from taking away benefits that have already been earned. However, it does not prevent a plan from being terminated. In 2026, the potential outcomes for a spouse like Rebecca hinge on whether the plan administrator has been formally put on notice that a portion of the account is contested property. If the notice is properly filed, the administrator is often required to hold the disputed funds in an escrow-like state within the plan even as other participants are paid out. This is a high-level maneuver that requires the coordination of family law attorneys and ERISA specialists, a level of expertise that many general practice firms simply do not possess. We must also examine the impact of a change in record keepers. Even if the company isn't merging or going bankrupt, they may simply switch from one financial provider to another, for example, moving the plan from Fidelity to Vanguard to save on administrative costs. This change often results in a new set of QDRO procedures. In American legal history, plan administrators have significant leeway in how they interpret QDRO requirements. An order that was pre-approved by Fidelity might be rejected by Vanguard for a minor phrasing issue. This creates a historical trend of administrative ping-pong, where a spouse can be caught in a loop of rejections for years simply because the corporate entity keeps changing its service providers. The depth of this corporate instability masterclass reveals that the 401k is not a static island of wealth. It is an integrated part of a corporate machine that is constantly evolving. To protect a retirement award in 2026, one must not only understand the laws of divorce but also the rhythms of the American boardroom. The merger, the blackout, and the termination are not just corporate buzzwords. They are events that can reset the clock on a divorce settlement and potentially drain the value of the asset through administrative attrition. But even if the company remains stable and the QDRO is perfectly drafted, there is a final massive hurdle that most people overlook until it is too late. This is the valuation of the non-monetary benefits. What happens to the health insurance subsidies, the life insurance components, or the restricted stock units that are often bundled with high-level 401k plans? In the next part of our series, we are going to dive into the executive package trap. We will look at how to split unvested stock options and why many spouses accidentally give away millions in future bonuses because they only looked at the 401k statement. We will also explore the forensic methods used to value these complex derivatives in a 2026 economy. In the next part, we unmask the hidden millions in executive benefits. The executive package trap begins where the 401k statement ends, often concealing the vast majority of a high earner's true net worth. In the American legal history of domestic relations, the most significant oversight in high-asset divorces is the failure to distinguish between qualified retirement plans, like the 401k, and non-qualified executive benefits. To understand why this is a million-dollar mistake, imagine a character named Mark, a chief technology officer for a major semiconductor firm in 2026. Mark has a 401k balance of $800,000, which is clearly listed on his quarterly statements. His spouse, Sarah, and her legal team might focus all their energy on splitting that $800,000. However, hidden within Mark's employment contract are restricted stock units, or RSUs, and non-qualified stock options, or NQSOs, with a fair market value exceeding $6 million. These assets are not part of the 401k. They are not governed by ERISA, and a standard QDRO cannot touch them. The first layer of this forensic hunt involves the restricted stock unit. In the historical trends of the 2020s, RSUs have largely replaced traditional stock options as the primary vehicle for executive compensation. An RSU is a promise by the employer to give the employee shares of company stock at a future date, once certain vesting conditions are met. The legal conflict arises when these RSUs are granted during the marriage, but do not vest until after the divorce is finalized. In American legal history, courts have developed specific mathematical formulas to handle this, the most famous being the time rule, or the Coover-Malone formula. Step by step, the court must determine the marital portion of these unvested shares. This involves a fraction where the numerator is the number of months from the date of the grant to the date of marital separation, and the denominator is the total number of months from the date of the grant to the date of vesting. Imagine if Mark was granted 10,000 RSUs in 2024 with a 4-year vesting schedule. If Mark and Sarah separate in 2026, exactly 24 months into that 48-month schedule, the historical legal trend in many states is to characterize 50% of those future shares as marital property. But the valuation is not simple. Because the shares have not yet been delivered, their future value is a variable. Forensic accountants in 2026 must account for potential outcomes including stock splits, dividends, and even the risk of forfeiture if Mark leaves the company before the vest date. This requires a constructive trust, a legal mechanism where Mark is ordered to hold Sarah's portion of the shares in a separate ledger until they vest, at which point he must transfer the after-tax proceeds to her. The second layer is the non-qualified stock option. Unlike RSUs, which have value as long as the stock price is above zero, stock options only have value if the market price is higher than the strike price. In the volatile 2026 economy, valuing these requires more than just looking at the current ticker symbol. Forensic experts use the Black-Scholes model, a historical gold standard in financial engineering, to determine the present value of a future option. This model takes into account the current stock price, the strike price, the time remaining until expiration, the risk-free interest rate, and the expected volatility of the stock. In a divorce, if the options are underwater, meaning the strike price is higher than the current market price, the employee spouse might argue they have zero value. However, historical case studies show that courts will still assign a marital value to these options because they represent a lottery ticket with a multi-year window for a potential windfall. Then we move into the realm of non-qualified deferred compensation, or NQDC, often governed by Section 409A of the Internal Revenue Code. These plans allow executives like Mark to defer a significant portion of their salary or bonuses until a future date, often retirement, to avoid current income taxes. Because these plans are unfunded and unsecured, they are technically part of the general assets of the corporation. If the company goes bankrupt, the executive becomes just another unsecured creditor. This lack of security makes them a nightmare to value in a divorce. Historically, courts have struggled with whether to value these at their face value, or to apply a discount for the risk of corporate insolvency. Furthermore, because these are not qualified plans, they do not support a QDRO. The transfer of an interest in an NQDC plan often triggers immediate taxation to the employee, which can lead to a potential outcome where Mark is hit with a 40% tax bill on money Sarah was just awarded. To navigate this, sophisticated legal teams in 2026 utilize a strategy known as the Callahan or Nelson approach, named after landmark cases in American legal history. This involves an if, as, and when distribution. Instead of trying to put a price tag on a complex executive benefit today, the court orders that the non-employee spouse will receive their percentage of the benefit if, as, and when it is actually paid out to the executive. This shifts the risk of corporate failure or market downturns equally onto both parties. However, this also creates a permanent financial link between ex-spouses that can last for decades, often leading to secondary litigation over whether the executive is intentionally delaying retirement or refusing to exercise options out of spite. The forensic audit of these millions requires a deep dive into the Form DEF 14A, also known as the proxy statement, which all publicly traded companies must file with the SEC. This document lists the compensation of the top 5 executives in granular detail. But for those below the top tier, the hunt moves to the internal grant agreements and the summary plan descriptions. A key step-by-step detail often missed is the change in control provision. If Mark's company is acquired in late 2026, his unvested RSUs might accelerate and vest immediately. If the divorce decree does not specifically address accelerated vesting, Sarah could lose out on a multimillion-dollar liquidation event that occurs just weeks after her divorce is final. We also see the emergence of the clawback risk as a major theme in 2026 legal studies. Many executive contracts now include provisions that allow the company to take back bonuses or stock if the executive is found guilty of misconduct, or if the company has to restate its earnings. If a spouse receives a distribution from a 401k or an executive plan, and that money is later clawed back by the company, the legal history is unclear on who is responsible for returning the funds. This illustrates the absolute necessity of indemnity clauses in the final settlement, protecting the non-employee spouse from the professional risks of the employee. As we peel back the layers of these executive benefits, we realize that the 401k was only the beginning of the journey. The complexity of RSUs, NQSOs, and 409A plans turns a simple asset split into a high-stakes chess match involving tax law, corporate finance, and forensic accounting. But even if you master the executive package, there is one final piece of the American retirement puzzle that is almost always miscalculated or ignored entirely by general practice lawyers. It is an asset that every working American has a stake in, yet its value is rarely balanced correctly against a 401k. In the final part of our masterclass, we are going to look at the Social Security offset. We will explore the shocking historical data on how failing to calculate the present value of Social Security benefits can leave one spouse with 30% less than they intended. We will also provide the ultimate 2026 checklist to ensure your QDRO survives the final administrative gauntlet. In the final part, we tackle the Social Security secret and the finish line. The Social Security secret is the final piece of the American retirement puzzle, and in the legal landscape of 2026, it remains the most frequent point of failure for even the most seasoned divorce attorneys. To understand the gravity of this, we must first look at a fundamental rule of federal law. Social Security benefits cannot be divided by a state court. Unlike a 401k, which is subject to the Qualified Domestic Relations Order process we have dissected over the last 9 parts, Social Security is governed by the Social Security Act, which contains a strict anti-assignment provision. This means a judge in a local county court cannot sign a piece of paper ordering the Social Security Administration to give half of one spouse's future monthly check to the other. This creates a massive valuation imbalance that has fueled decades of American legal history studies. Imagine a character named Robert, a high-earning executive who has maximized his Social Security contributions for 35 years. His wife, Emily, spent 20 of those years out of the workforce raising their children. In their 2026 divorce, they are splitting a $1.5 million 401k 50-50. On paper, it looks like a fair and equitable distribution. However, Robert is on track to receive approximately $4,000 per month in Social Security benefits at full retirement age. Emily, due to her lower lifetime earnings, may only be on track for $1,200 per month. If we calculate the present value of that $2,800 monthly gap over a 20-year retirement, Robert is effectively walking away with an additional $400,000 to $600,000 in hidden retirement wealth that was never put on the marital balance sheet. Historical trends in states like Ohio, Pennsylvania, and Massachusetts have attempted to solve this through the Social Security offset. In these jurisdictions, courts may look at the present value of the Social Security benefits each spouse has earned during the marriage. If one spouse has a government pension, like a teacher or a police officer, that was earned in lieu of Social Security, the court may offset the value of that pension by the value of the other spouse's Social Security. The step-by-step math involved in this is grueling. A forensic economist must be brought in to project future benefits, adjust for inflation, and then discount those future payments back to a lump sum value in today's dollars. Failure to perform this calculation in 2026 often leads to potential outcomes where one spouse enters retirement with significantly more purchasing power than the other, despite a supposedly equal split of the 401k. This leads us to the 10-year rule, a critical historical threshold for derivative benefits. Under federal law, if a marriage lasted at least 10 years, a divorced spouse like Emily is entitled to claim Social Security benefits based on Robert's earnings record, provided she remains unmarried and is at least 62 years old. The most important detail here is that Emily's claim does not reduce Robert's own benefit, nor does it reduce the benefit of any future spouse Robert might have. This is essentially a phantom asset, provided by the federal government. In the legal history of the 1970s and 80s, this rule was a hard-fought victory for stay-at-home spouses. In 2026, it remains a strategic anchor in divorce negotiations. If a couple is at 9 years and 6 months of marriage, a savvy attorney will often suggest delaying the final decree by 6 months to hit that 10-year mark, as the present value of those lifetime derivative benefits can be worth hundreds of thousands of dollars. But the Social Security secret is only one part of the final finish line. As we conclude this masterclass, we must address the ultimate 2026 administrative gauntlet, the post-QDRO implementation phase. Most people believe the journey ends when the judge signs the order. In reality, that is only the halfway point. Step by step, you must navigate the acceptance period. Once the signed QDRO is sent to the plan administrator, whether it is Fidelity, Vanguard, or a private corporate trustee, they have up to 90 days to review it. During this time, they are looking for any deviation from the plan's specific, qualifying criteria. Historical data shows that nearly 20% of QDROs are rejected on the first attempt due to minor clerical errors, such as using the wrong name for the plan or failing to specify how the $1,000 administrative fee should be paid. To ensure your 401k split survives this gauntlet, you must follow the 2026 Ultimate QDRO checklist. First, confirm the exact legal name of the plan. A 401k is often legally titled as a profit-sharing plan or an employee savings trust. Second, define the valuation date with absolute precision. Is it the date of separation, the date of the divorce filing, or the date of the final decree? As we saw in Part 2, a 1-month difference in a volatile market can change the award by tens of thousands of dollars. Third, explicitly state whether the award includes pro rata earnings and losses. Without this phrase, you are giving away the market growth on your portion during the months of administrative delay. Fourth, designate the survivor rights. If the employee spouse dies before the money is moved, and you are not named as the surviving spouse in the QDRO, the plan may default the entire balance to a new spouse or the estate, leaving you with nothing. Finally, you must address the account opening phase. Even after the plan administrator qualifies the order, they will not simply mail you a check for $500,000. They will typically create a segregated account in your name within the existing plan. You must then proactively move that money into your own IRA or another 401k. Historical trends show a high rate of abandoned QDROs, where a spouse is awarded money but never completes the paperwork to move it. By the time they try to access it 10 years later, the company may have merged, the plan may have been terminated, and the records may have vanished into a corporate archive, leading to a legal nightmare to recover the funds. The American legal history of the 401k and divorce is a story of the shift from communal stability to individual risk. In the mid-20th century, pensions were simple, but they often left spouses with nothing. Today, the 401k provides a visible liquid asset, but it comes with a level of technical complexity that can be weaponized against the uninformed. We have traveled from the origins of ERISA in 1974, through the tax wars of the 1980s, past the liquidated asset traps of the 2000s, and into the executive compensation minefields of 2026. The finish line of a 401k divorce is not just about getting a share of the money. It is about preserving the value of that money against taxes, penalties, market swings, and corporate instability. It is about understanding that your retirement is not a static number on a screen, but a complex intersection of federal statutes and state property laws. By mastering the QDRO, the Social Security offset, and the forensic hunt for hidden assets, you are not just settling a legal case. You are securing the next 30 years of your life. The masterclass is now complete. You have the tools, the historical context, and the technical step-by-step detail to navigate the most litigated asset in the modern American court system. Your golden years are no longer a matter of chance. They are a matter of precise legal execution.